access report, which some of you may have seen, some of you may not. I brought copies with me. I thought this was the appropriate way to bring copies to this kind of conference on a pen drive. But we're also going to show the website where you can access the report. Basically, the report was some research that was conducted during the course of this year, looking at four things. We looked at the open government data movement and what it's achieved. It's a very exciting time. I mean, someone said this morning, this is something really new, it's exciting. To try to write a report about this movement in 2010 is almost impossible because it's a moving target. It's very dynamic, there's a lot of energy and initiative. We also looked at the access to information or freedom of information movement, and which has been working for over the last maybe 15 plus years to promote the right of access to information. And this is a movement which is fairly strongly established, very networked globally, and has done a tremendous job in changing from 15 years ago when there were about 15 Freedom of Information Acts worldwide to today in 2010 when there are over 80 countries which have recognized a right of access to government information. We looked then at the technical obstacles. What are the kind of problems with getting access to information held by government, whether you're looking at it from a right of access to information perspective or from an open government data perspective, and I'll come back to that in a moment. And we looked at the legal obstacles to both accessing and reusing information. What did we find? We found that on the technical side, you have a right of access in all these 80 countries at least to information held by government bodies, information or documents depending on the national law, but there's a lack of clarity on whether or not there's a right of access to information in electronic format. Interestingly, Sweden, which adopted, it was the first country in the world to adopt an access to information law back in 1766. Well, obviously, in 1766, they hadn't anticipated the need to get access to electronic information. And it's not in the Swedish law. And investigative journalists in Sweden, to this day, cannot insist that they have access to information electronically. In some other countries, yes, but not in all countries. There's some doubt about whether you have the right of access to a whole database, because some laws, the Danish law, for example, says a database is not a document, it's something else. So some of the older European laws, not the law in Britain, which is a younger freedom of information law, but some of the older European laws which talk about documents exclude databases. The European Union has proposed to clarify the access rules for the European Union by saying a database is not a document. That would be a huge problem for the open government data movement in terms of access to information at the EU level. That's a big problem. Is there a right to machine readable information? Not one single access to information law in the world recognizes a right of access to machine readable information. Is there a right to have the information in an open specification so that it's easy for reuse? Again, not established from a rights perspective. So some of these gains which have been made by the open government data movement in terms of getting access to information electronically, the full database in a machine readable format, maybe with in a sort of open source format, fantastic, but these are not gains which are backed up by law. What that means is that they're subject to the vagaries of political will. And what was interesting from our perspective was to say, how can we look at what's being achieved and really entrench it in a way that it remains? And we heard people talking this morning about the danger of backtracking on what's been achieved. With respect to the legal obstacles, we found, I would say, three main legal obstacles which are currently or could prove to be impediments to the open government data movement. The first one is whether or not government, who owns the information at the end of the day? Who owns the information? Do we own it? It was created by governments that we elected using our tax funds. Surely it's our information. You'll find many freedom of information activists have been arguing for years, it's our information. But if you look at the legal framework in many countries a bit more closely, in fact, governments copyright at least certain parts of government information. I mean, the UK is a paradigm for that. So much information is copyrighted. We're seeing a move now in some countries, New Zealand, for example, Catalonia has just done it in the last week or month or something. I was catching up with my emails this weekend. I don't know when they did it. We're seeing governments now releasing data under Creative Commons licenses so that there's no real copyright, intellectual property restrictions on reuse. Is that enough? Or should we go one step further and say, as they have done at the federal level in the United States, government information should not be copyrighted? That's an open question for us to discuss. What about charging for information? Again, the same who owns the data, who owns the information question applies. If the information is public information, what possible grounds can there be, from a rights-based perspective at least, to charge for the reuse of that information? I've been looking at this during the course of this year, and I cannot find any arguments which justify governments charging for information, at least if that information was created as part of their core government functions. And the third problem is, do we have a right to reuse the information which would overcome these technical and legal obstacles, overcome the copyright problem and the charging problem? Interestingly, last year, and this is very new, so just in the way that the open government data movement is really moving ahead very rapidly at the moment, exciting things are also happening in the world of access to information. Last year, the European Court of Human Rights recognized that the right of access to public information is linked to the right to freedom of expression. They said that when information is held by a monopoly, then the public has a right of access to that, if the monopoly is a public body, to exercise your right to freedom of expression. This could be tremendously useful in arguing for the release of certain government data sets, when we could say, we need this information in order to be able to have a public debate around spending, for example. Now, I just want to make a comment on some of the new developments, like this announcement this morning in the UK. It's fantastic. It's fantastic that the British government has released some of this spending data in more detail. But let's not be fooled into thinking that this is a completely world-leading initiative. You can look around the world, contracts. Someone said maybe the British government will put contracts online next year. Many countries around the world have government contracts online already. Not from open government data reasons and arguments, but because the UN Convention Against Corruption requires that certain information be published. If you go, I don't know, in Slovakia, for example, do you have contracts online? Parts of them. In September, okay. Well, Canada's had contracts online for ages. I think in Romania you have contracts online. So some of these initiatives which are being taken to put data online in the UK have already been implemented elsewhere. This leads to our main conclusion and my final point, which is about strategies going forward. What we found in the Beyond Access research is that the freedom of information movement and the open government data movement have not yet been collaborating to the extent that they could. I think this event here today is going to be very important. We've got a panel this afternoon where we've brought together people who are working on both. People who've been doing things like going to court and getting the court to order, this is the case in Israel, for example, getting the court to order that the information be released in a machine-readable format. There are some very exciting things happening in different countries around the world, being achieved by freedom of information advocates, which could help bolster and support and provide a long-term foundation for the open government data movement. The question is, what are our strategies? I have one big doubt about something that's being discussed at this conference, and I'd like to throw this open because I think it's very important that we discuss it. Do we need a new right to data? I'm not convinced about that, because I think we already have a right of access to information, a right that is recognized in many constitutions and is recognized by international human rights tribunals. I think that rather than creating something new, rather than reinventing the wheel, we should look at the existing achievements on the right of access to information, which would include, maybe we need some refinements in the implementation at the national level. We need to argue that the right of access to information in the 21st century includes the right of access to information in electronic format, at least where it already exists in that format. But maybe that would be a more effective strategy than trying to start from square one with a new right to data, which is not recognized in any constitution yet, nor in any international human rights treaty. That's something that we're going to discuss in more detail in a panel this afternoon. I think I probably used my 10 minutes, more maybe.
Pretty much, yes.
Yes, and thank you very much for your attention. I can take